Hey, good morning. It's Jack from Jack Gately Real Estate and the Online Real Estate Academy. Thank you so much for joining us today. It is Tuesday, and let's get right into it. So, over the weekend, I was very eager to read the responses from the plaintiffs to the Department of Justice statement of interest in the MLSPIN Nosalek case. But instead of a long legal treatise, we instead got a letter from the plaintiff's attorney. Let's see if we can bring it up here on your screen. Here we go here. This is from Seth Klein. Seth Klein is the attorney for the plaintiffs in the MLSPIN Nosalek case, which for those of you who are not up to date, because most of you are focused on the Kansas City Bombshell Commission lawsuit, which NAR lost last October out in Kansas City. This is a much smaller dollar figure case, but has, I think, equal repercussions when it comes to the potential rules for the industry. And that I'm much more interested in the rules going forward. And as a business person, I want clear rules that are clear, and I want stability, right? I'll take whatever rules package you give me, but I want clear and I want stable. And in this video today, what we're going to go over is effectively what I see as a path forward, how to change the listing agreement, how to change the multiple listing service, and how to change buyer representation agreements going forward based upon what we know at this current moment. And I'm going to, how do I want to say this? Reserve the opportunity to revise my remarks in the future. Thank you so much for joining us this Tuesday morning, by the way. Thanks for being here. Should things change? But this is how I'm seeing it at the moment. Let's bring up this letter once again from Mr. Klein from this law firm in Connecticut, which instead of the detailed legal briefings that were expected to see, instead we got this one-page letter from Mr. Klein. So Mr. Klein is effectively the, how do I want to say this, the Michael Ketchmark of the MLSPIN Nosalek case. Let's call him that, right? That's probably disrespecting Mr. Klein, but you know what I'm trying to say. So here he is. And what he's saying here in the first sentence is that MLSPIN, the Department of Justice, and the plaintiffs discuss questions raised by the court concerning the MLSPIN settlement and prepare a joint statement to be filed on or before June 21st. So in my video from last week, I told you that the next big date on this case was June 21st, and maybe I'd put that on my calendar and actually try to attend the proceedings at the courthouse myself. But sometime before then, on or before, and you know how lawyers are, right? Work expands with the time allotted. Chances are this will go right up to the deadline, most likely. On or before June 21st, the three parties in this case, the plaintiffs, Nosalek et al., the Department of Justice, and MLSPIN, the defendants, all three of those parties in this case are aiming to issue a joint statement to be filed with the court on or before June 21st. So basically what this is kind of like, if we could kind of make a grade school analogy here, this is kind of like the teacher saying, hey, you two kids over there, I don't like what's happening over there, and you better work it out on your own, or I'm going to come over there and decide who's right and who's wrong. And maybe both of you are wrong. In other words, this is an opportunity for the parties to kind of come together and say, okay, let's settle it on our terms before the judge settles it for us, right? I mean, that's basically what they're saying here. And there's a bunch of other legal gobbledygook here, basically saying we reserve the right, I think, to file the additional lengthy legal briefings if we want to. But mostly, basically, what they're saying is they're going to try to come to some terms amongst the three of them. They're going to try to make a settlement effectively. Okay. So who is this guy, Mr. Klein? Because he hasn't gotten a lot of attention recently, has he? No, there's certainly not nearly as much publicity as Mr. Ketchmark. But you can find a quote from Mr. Klein in the Inman article from when was this? There we go. That's better. Hold on a second. Let me slide that up. In the Inman article on this topic from last week. Here we go here. The plaintiff's attorney, Mr. Seth Klein, declined to comment on the hearing Wednesday. But in court, Klein appeared to confirm Zorn and DeWiggin's interpretation, which is also my interpretation. Ideally, in their statement, the Department of Justice statement, they say they want to prohibit the seller from offering compensation at all. I think from that statement, their ultimate position on what they think the world should look like, I don't necessarily disagree. So if there's going to be a joint statement between the Department of Justice, the plaintiffs, and the MLSPIN, and you already have the Department of Justice and the plaintiffs on the same side, then basically the ball's in the MLSPIN court here to settle. Now, a legal important point is that MLSPIN is broker owned. It's not owned by the realtors, and the realtors, let me just make sure I just mispronounce it just to piss a half of my audience off. Realtors. MLSPIN is not owned by the realtors, but the rules are almost exactly the same. And almost exactly the same. And most of the brokers that own MLSPIN stock, now I don't have any numbers on this, but I strongly believe that most of the brokers that own MLSPIN stock are members of the National Association. So it's not owned by the realtors, but it's realtor influenced. Can we say that? I think that's a fair way to characterize it. And you don't have to be a realtor to be a member of MLSPIN. And I am a member of MLSPIN, but of course I'm not a realtor. So there you go. It seems as if the deck is stacked against MLSPIN. And as I've been saying for a couple weeks now, that the rules package might be determined here in Massachusetts, where the money package is kind of already been determined out in Kansas City. See so the bifurcated result here, which I don't think a lot of people, I don't think a lot of people in the business have yet wrapped their mind around yet, but I think it's important to realize that the money might be coming out of the Kansas City case, but the rules might be coming out of Massachusetts. All right, so should this happen, what would this all look like for our listing agreement? Let's bring that back on the screen here. Our listing agreement here, the MLS in the future, and the buyer representation agreement. So let's take the listing agreement first. So in a listing agreement, bring up the old chalkboard, right? In the listing agreement, at least two things are going to have to change. There's a section, we'll just call it section 1 for kicks, but there's a section that outlines the total percentage, right? And you fill in the blank on that, right? Because it's variable, it's negotiable. We'll just say 5%. And that's the total compensation that the seller pays for the sale of their home. And then there's a section right after that, we'll just call it section 2. And this is going to be the buyer agency share, right? This is going to be the buyer agency share. And of course, this is also a blank, which you fill in. And let's just say 2.5%. That's how it works now in most places across the country. So the seller pays 5%, and the seller is authorizing the list agency to advertise and pay, which is a binding obligation by their MLS membership, 2.5% to the agency that brings the buyer. Let's remember that the current flow of money, and I think this is important, when a seller sells their house, technically the entire 5% goes to the listing agency, and then they share that technically with the buyer agency. Okay, so that has to go away. That section 2 is going to have to go away under these new rules. Would there be anything in Section 2? That's a good question. I think, consequently, at the very minimum, we're going to have to change Section 1 to only pay the seller agency. So let's just say 2.5%. And that's for the seller agency only. For the seller agency only. And then Section 2, if it exists at all, and I think this is a question mark, but would it be acceptable to the parties to allow the list agency to indicate that the seller is, how do we want to say that, offering up to, let's just say 2% in this case, but it's not binding. Not binding. I think this is the incredibly important part of this potential solution, that it's not binding, that it's going to vary based upon the offer, because this says this authorizes the list agency to say, hey, the seller is considering offers, considering paying the buyer agency up to 2%, but it's not binding. This would be the same way that listing your house is not an offer. So if you list your house for $500,000, that is not an offer. That's just an advertisement. And also listing it with an offer to pay the buyer side commission is just an advertisement. It is not an offer of commission. It's something that we'd be willing to entertain. And of course, if you're going to make an offer of $450, but we listed it at $500, we're probably not going to be entertaining your 2% commission anymore. We're probably going to be entertaining something a lot less because your offer went down. We're just saying we'd entertain a maximum of 2%, not binding. So I don't know if the Department of Justice would go for that. I think this is a better solution, but I'm going to put a question mark on that. But I would prefer this to allow the seller at least to advertise what they're willing, if anything, to pay. Now, this brings up a lot of issues like, especially like, what do you want to put in this blank? Because obviously this would be a blank that you'd fill in, and this would be too. And maybe this brings up all sorts of troublesome discussions about steering. So maybe you can't do this. I'm just floating it as an idea. You tell me in the comments. I'm interested in what you have to say about that. Over on the MLS, what has to go away is the mandate, which is actually already gone away, right? You can now offer as little as $0. So the mandate's already gone. You can offer as little as $0. And also the field that of the agency, the list agency, offering a fee, the list agency fee, which, we now populate all over the internet, where you can go on Zillow and you can see what the list agency is going to pay. That has to go away. And maybe it's replaced by Jack's solution, which is the seller up to non-binding offer, or I don't even want to call it offer, consideration, advertisement, whatever. If that flies with the Department of Justice, right? If that flies with maybe the MLS can include a number that the seller would be willing to accept, but is not bound to accept, which is not bound to accept. That would, I think, be the best solution. But again, just spitballing here. You tell me. On the buyer agency representation agreement. So on the buyer agency representation agreement, there is a proposal by NAR to mandate that. I am against mandates, generally speaking, and I am against mandates in this case here. I prefer the free market. I just got to say that, like, my gut feeling is that a mandate for buyer agency representation agreements is a backdoor to further legal trouble. In other words, the Department of Justice will come back again and say that a buyer agency mandation agreement is a way to inflate fees. How do you spell that? You know how to spell it. You know the thing. I think that they're going to come back in next year or whenever it is, and they're going to say a mandate that you have to have a buyer agency agreement is going to be a way that inflate fees. I'm just very, very, very worried about it. Now, if you're a broker and you run an agency and you want to tell your agents, your 109 agents that you have, and you want to tell them, hey, we're doing buyer agency agreements every time. Well, that's your right as the broker for those 109 agents. You go make that decision. Fine. If you're a broker and you want to tell your agents, hey, you can do it or not do it, it's your choice. Fine. Yeah, this is the way I'm looking at it, but I think a mandate is a step in the wrong direction because it's going to create further legal trouble, which we don't want. Remember, we want, number one thing, we want clarity and stability for the rules. And also, as has been exposed in many people's videos and writings, how do you enforce that, right? The whole Zillow thing that they came up with was an absolute joke. I mean, that only benefits Zillow. And how do you really enforce that you have a written buyer agency agreement before you go see a house? Who does the enforcement? It's just a joke, right? It's complete. It's a complete, can I say shit show? Yeah. Okay. Let's say it. It's a shit show, right? So that's just dumb. It's completely dumb. And I think it comes from the worst instincts of NAR. I think it comes from the worst instincts of NAR to have a mandated buyer agency agreement because they think it would be a way to, how do I want to say this, perpetuate the conspiracy. And yeah, you don't want that. So in my opinion. All right, getting back to the Department of Justice rules. Again, on page 20 of the MLSPIN Nosalek Statement of Interest. If MLS rules prohibit sellers and listing brokers from deciding what buyer brokers would be paid, sellers would be responsible for determining only the compensation of their own broker in the listing contract, while buyers would be responsible for determining the compensation of their own broker in the buyer broker representation contract, if they wanted to do it that way. Now, it would make a lot of sense to have a buyer broker representation contract, but I don't want to mandate it. That's just the way I think about it. I don't believe, reading this sentence, that there's anything wrong with at least advertising the fact that the seller would at least entertain paying a certain fee, but have it not be binding, as the Department of Justice itself entertains on the next page when they say a change that the buyer makes it the buyer's responsibility to negotiate broker commissions directly with their buyer broker would not force buyers to pay those commissions out of pocket. While some buyers might choose to pay their buyers out of pocket, other buyers might request in an offer that the seller pay a specified amount to the broker from the proceeds of the home sale. Thus, the current practice could continue. We've covered this many, many times before. So, that's just how I feel about it. If you're willing to produce a list price, $500,000, and that's not an offer. That is not an offer, and you are not bound. Are you bound to sell your house for $500,000 if you list it for $500,000? I'll wait until I get my answer. No. So why couldn't you also include in that I'm offering it for $500? and I would consider a 2% fee, but have no binding on that, right? Now, that's different than like if you go to the Dick's Sporting Goods and you pick up a basketball off the shelf, or you pick up a Yeti. You pick up a Yeti off the shelf. How much does a Yeti go for? Pick up a Yeti off the shelf. It says $25. They're bound to sell it to you for $25. There's all sorts of consumer protection laws in regards to that. But when you sell your house, it's different. You're listing it for $500, but you could sell it for $600, or you might sell it for $425. And I think you could do that same thing with the commission. All right, we have a number of comments here, so let's pick up the comments. Jennifer says, poor buyers. Yeah, I appreciate that comment, Jennifer. I don't know. This is not Jack Gately's perfect world here. And I think we have to dismiss the possibility that there is a perfect world. I don't think there is a perfect world. I think we could move to something better. And I think sellers paying their fees, buyers paying their fees, and sellers, when they want to, offering to pay a fee. Yeah, fine. Going to go back to my original analogy probably a couple of years ago. This is going to be more like the Boston apartment rental market, when, based upon market conditions, the landlords sometimes pay the rental fee, but typically the tenant pays it in the Boston rental. But it varies with supply and demand. It varies with supply and demand. Right about now, in the summertime, once all the kids go, graduations are over, then the landlords look at how many apartments they have left. I've got 30, I've got 109. How many they have left for September 1st that aren't rented yet? And then they decide, based upon, looking at prior years, and they decide whether or not they're going to be able to rent those over the next couple months, because you don't want to miss September 1st. If you don't rent your apartment by September 1st, there's a technical word for it, you're bleeped. So sometime between now and, say, August 1st, the landlords start paying some, if not all, of the fee. And this should be variable based upon market conditions. Right now, in a lot of the country, at least here in Massachusetts, it's a seller's market. And so right now, the sellers might not want to pay any of the fee. And of course, that's a savings for the sellers. And should we ever get back into a market that's more like 2011, then it will be a buyer's market, and the sellers were going to want to pay a fee. So I think it's variable. It makes it more confusing. But yeah, great question, Jennifer. William says, how about putting that seller is willing to entertain paying commission with no percentage mentioned? Okay, yeah, make it. I don't know if you really. I guess so. Yeah, so no percentage. Maybe that walks a fine line, but then you've got the questions like, how much, right? So I guess you have to ask that question. Yeah, I don't know. It seems to me that the MLS is the best way to distribute that information. But as I satirically mocked the NAR settlement, and I came up with a completely stupid and satirical commissionpost.com. Remember when I came up with that? It was like a month ago, where you could actually, with a seller, could post the commission they wanted to offer because they can't do it on the MLS anymore. Understand that if you cannot post what the seller is bound to offer or would entertain non-binding, somebody else will do it somewhere in the marketplace. So even if it's not on the MLS. And I think if it's a non-binding offer of commission, I think that's where we have the opportunity maybe to do that and to avoid any type of antitrust problem with that. But of course, I'm not a lawyer. What do I know? Jennifer said, it doesn't matter what we speculate. None of this is in our control. I don't know about that. I think there's the court of public opinion. And if you're a realtor, I think you have a voice. If you're an MLSPIN member, I think you have a voice. I think so. We need let's bring up Sharon's here quote. Good morning, and everything is negotiable, so treat it as an option for sellers. Yes, that's, I think, what I'm saying, Sharon. Yes, good morning, and hope you had a great weekend. Our current situation allows buyers to roll all the costs into their loan. The new situation will prevent buyers from rolling it into their loan. They now need to come up with the extra costs out of pocket. Okay, so that's a popular misconception, and let's bring that up here in this page 21. So it says right here, Jennifer, if buyers request in an offer that the seller pay her buyer broker from the proceeds of the sale, it would be straightforward for the seller to compare offers that include a request for the seller to pay the buyer's broker. A seller only has to compare dollar amounts. This type of conditional offer is already permitted under federal lending programs. These programs do not require buyers to come up with additional funds. So your comment, and I mean this in the nicest way possible, is just not true, according to the Department of Justice. So I would strongly recommend that you read page 20 and 21 of their Nosalek statement of interest, which I'm happy to tell you is linked in the description of this video. Somewhere linked in the description of this video. So I thought I would be coming up with a whole legal analysis of their point of view, but instead, basically, they're saying maybe we can settle it on our own between now and June 21st. Again, work expands usually with the time allotted, so I would imagine this would go almost all to June 21st. But we'll see. If it comes out sooner, we'll keep a very close eye on it. Any other comments for today? I don't think so. But seriously, I think all of you that are watching should definitely read page 20 and 21 with the fine-tooth comb of the Nosalek settlement. So that's the way we see it going in the current projectile? No, what's the word I want to say? How it's currently projecting that we might have a rules package and out of this, which would be technically not bounding, NAR is not a part of this potential joint statement, but certainly their MLSPIN is NAR influenced, aren't they? Right? Because almost all of their broker owners are realtors, right? And yeah, exactly. Right. Of course. All right. Hey, it's been great to be with you today. I think we have got a number of other videos I want to make for you this week. So maybe even another one today, and go make some money. Have a great week. Bye-bye.